Okay, we are on Facebook Live now.
But they can't hear me yet, right?
Yep, we only allow them to log in by 3 o'clock, right?
Hear us.
Jacob, only log in, right?
Just stand by.
Stand by, right? Not yet, right? Right.
陣間我同CS 講鹹濕股嗰陣時，人哋聽到啊。
佢哋要聽嘅咁樣講。
好似聽到咧，出邊聽到啊 CS。
聽到。
Okay.
People are starting logging in now. Okay, please stand by. We start at 3 p.m.
So nervous lah.
Relax. I'm not mute yet. Ina, you get to listen for more than half an hour first, what?
Okay.
You know, and I'll introduce you. If fumble, I fumble first. You don't worry. Just go slow, you know, Ina.
Right. I think I have a lot to share as well.
You have a what?
I already made a proper note. So from the notes, I think I have a lot to share. It's quite a lot to share.
Yeah. You have. So, but you don't have to say everything on the slide. You just mention the few keywords, and then so long as your message is over, and then you leave the slides for them to upload onto SME website so that the members can download it. That's how I'm going to do it.
Is the audience downloading it on the spot?
No, the past two, they can go to the website to download.
Oh, okay.
But they'll see it on the screen while we talk.
We only will email to those people who registered our site, who requested for their.
Yeah, lah. At your SME site and our members, lah, right? Okay. Good, that means those who want to get the slide will join SME as a member, ma. Yes. So if there is anything on the subsidy issues, you have to come in, huh, bro?
Right. Don't worry. I think Michael will join later.
I see. Okay.
We'll try his best.
But he's starting 2:30 in Putrajaya already, right?
Yeah. Cup very big, ah.
Got echo.
Got echo, ah.
Yeah, got echo. Who open two devices?
Oh, me.
Cannot two devices. Sure got echo. You have to off one.
Okay, done. What are you saying, Chin?
I say your cup very big, very nice.
Oh, from Middle Temple.
Okay, we have people coming in already.
Where can you see people coming in?
See the name all down there on the screen.
Oh, yeah.
We have Jeff Wing inside already.
I see there's a band.
Okay. Yes, I think we can start now.
Any issue with logging in, Jacob? All right.
All right. Okay.
We can start now, right?
Yes.
Great. Good afternoon, ladies and gentlemen. Good to see you again, some of you. And for those who just joined us, thank you for joining this session with us under the SME Malaysia. We have a fine gentleman with his team here to help us to talk about the legal issue pertaining and the option of the SME during this period of time. I do hope that this session can bring benefit to you. And I know that Arthur and his team already started to prepare many slides and many info for all of you to listen to and have the option of what is going to happen if you do take some action or some legal matter that related to employment, to contracts, as well as to insolvency. You know, what happens if someone goes bankrupt? What happens if you want to wind up your company? What you need to do? Do you need to do any voluntary arrangement for retirement plan for your staff? What is the legal implication? And we have the gentlemen here to introduce to you a long presentation they have prepared to go through. Then we'll go to the Q&A session. Today, of course, we have Arthur Wang, who's the main person here. He is from Arthur Lien and Associates. Little introduction to him, for him to all of you. I've known Arthur Wang for quite a number of years, and he's a fine gentleman. You can see him later. And he's a law graduate from Cardiff Law School and was called to the English bar in 1992. He worked in London, England for a couple of years, including a Palm Court Middle Temple and also the British Telecom, before he decided to come back to practice in Malaysia in 1994. Arthur is a litigator and has appeared in English court all the way to the House of Lords and has many reported cases in Malaysia too. Personally, I have also experienced working with him in some legal matter. He's good. He has acted for many listed companies and is also the counsel for Bar Council in Malaysia. And he acted for the Bar Disciplinary Board against the famous Shafi Abdullah. He take against Shafi Abdullah. He's a great guy. And all the way to the federal court. I believe his experience will help us. Please ready some questions for him and his team from all the presentation he have for you. Even you have any other question related to SME facing during this pandemic period, you can also reach it out to them. And for your information, Arthur is also the legal advisor for our SME Malaysia, right? And he is also the Malaysia Chinese Chamber of Commerce legal advisor, including many other associations as well. He's so active in advising organizations relating to sport, education, and also religion. I think we will have a lot of things to learn from him today. I hope you can keep all your questions at the end of it. And for your information too, our president, Dr. Michael Kang, will be joining us later because he's called to have a meeting in the Prime Minister Department at 2:30. And now he's having a meeting there at the EPU in Putrajaya. Hopefully, he will join us as soon as finish the meeting. Nevertheless, if there are any questions that you want to ask regarding the grants, whatever other information during this MCO period, you could bring up those questions too. But today, we hope that you can focus your question towards our three person from Arthur Lien and Associates course, we have Arthur Wang. He will be assisted by Nurul Fahina. He's another presenter, which will help him later. You can call her Ina, as well as Wong Hui Hong, who has prepared all the slides for you today. For your information, if you need the slide, you could go to our website, smemalaysia.org, to register and request for the slide. We will email to you from there on. Okay, without further ado, I would like to pass the mic, or I would say mic for the screen, to Mr. Arthur Wang to start his presentation here today. Thank you, everybody.
Hello. Good afternoon, everyone. Welcome to this session of the SME lectures. I will start off with the slides. Let me put on the slides first. Okay. Well, that was the firm. If you can start with the introduction. We are at the moment in the Movement Control Order, MCO. We started on the 18th of March, the first phase 1. Phase 2 was 1st of April. And today is the first day of phase 3 of the MCO. Now, what's going to happen after the 28th? Really, nobody knows at the moment. But suffice to say that where it first started in Wuhan, they didn't stop the MCO or the lockdown until they reached a 0 new case scenario. So when will we be achieving that target? Nobody knows. But to look at MCO and COVID-19 as an issue that is affecting us, that is definitely a serious issue. What we are trying to do in this lecture is to bring up issues so that you'll be able to see what is happening all over the world, prepare yourself as to what are the external issues, and then look into the internal issues that you have, and then lastly, be prepared to see and plan what are your steps. Today, we will be talking on mainly 3 topics. Topic 1 will be related to employment law. The second issue would be pertaining to contract, and in essence, talking about force majeure. It's a very interesting issue that everybody is very concerned. And a related issue known as doctrine of frustration. And then the third thing that we will be talking, the third topic that we'll be talking about would be on insolvency. That's when Nurul Fahina, my partner, will be talking on. In essence, she practiced a lot in that area, and we will be explaining to you what are the issues in bankruptcy. Okay, let's start with employment. The importance of having an employment contract. The importance of having an employment contract. In essence, the employment contract spells out the right and obligations of the parties. Hang on. I'm having some issue with the slides. Can everybody see the slide?
We can see.
Okay, thank you. Good. The importance of having an employment contract is, in essence, you have a contract whereby you have a document that will spell out your terms, obligations of the employer, and what are your job scope. If you don't have an employment contract, it'll be difficult to know what parties have agreed to and where do you go. And when you have dispute, unless you are able to settle among parties, it will become a legal dispute. Okay, we have prepared some of the key points where you should look into insofar as what should be in your employment contract. These are the issues. I'll go through very quickly. So the rest of it you can get from the website and download the contents of today's slides. Yeah. Okay. This we have extracted from the Ministry of Manpower in Singapore. It is what they have prepared as the key employment terms. They have prepared one. I think it's a good template. You all can have a look at it. I'm going to move on to termination. Now, what's a termination? There are two types of termination. In essence, one voluntary termination, the other is involuntary termination. Voluntary termination would mean that the employee will terminate and resign. Involuntary is one that the employer gives a notice, is more commonly known as a dismissal. Okay, what are the situations that the employer can terminate? Okay, under Section 11 of the Employment Act, you can terminate when the contract of service expires. Under Section 2, when notice of termination has been served to the employee. Section 13, when the employee commits a willful breach. Section 14, when there is misconduct. Other reasons to justify a dismissal is poor performance or negligence. Now, for termination, the most common question that's being asked is whether domestic inquiry is required under the law. Under Section 14, whenever an employer wishes to terminate on the grounds of misconduct, i.e. he is not in compliance with the express or implied conditions of his service, then you have to have an inquiry. You have to have an inquiry. So previously, whenever you have a labor case or industrial relations case, and you don't have what is known as a DI, domestic inquiry, it is almost fatal. It is fatal to the employer's case. So if you've not done a DI and the employee sues you to court or labor court, that's 99% that you will die. You will lose the case. However, in 2019, there's a court case. Not too many people follow this, but nonetheless, there's an argument that says that even when there is no DI, during the court hearing, they can conduct the inquiry. Okay, so that was a case in 2019. However, okay, now next issue: can an employer unilaterally terminate the employment contract of a probationer? Now, there are two positions. One, in Court of Appeal in 1997, the court decided that even during probation, okay, an apprentice is also to be taken as a normal employee, and therefore all the employees' rights and benefits as per the contract is open to them. So as such, in order to terminate a probationer, it would be the same as terminating an employee. Okay, so in federal court in 1981, there was a decision that says that when it is a probationer, at the end of the probation, then the employer can either confirm or terminate the probationer's service. There is no requirement to do a DI in those circumstances. So the takeaway from this, from these two cases, is in essence for a probationer, the best way to do is to hold on your decision until the end or the expiry of the probation period. Then you can decide just not to continue but you need to give notice to the probationer to say that you're not continuing with you. Okay, the next thing is whether employer needs to expressly warn the probationer prior to dismissal. The answer is yes, if you want to dismiss. This is different from a situation that I've discussed just now, whereby it's at the end of the probation. So during the probation, it's important. Okay, this is decided in 2004, where the employer must prove that the probationer had been warned and given sufficient time to improve himself. So if you want to terminate anyone, actually even employees, during their employment time, you must be able to give them warning as to what is the failure and give them chance to improve themselves. It's only when they cannot improve themselves, given the chance to, then you have the right to terminate. Now in 2000, in the case known as Robert John Reeves, the position is somewhat different with senior staff. So for the senior staffs, it's slightly better because it is expected of them that they must know the standards required of them and the improvement if they are not at par. So you don't have to have as much notice or warning for senior management staff. Okay, the next issue that I like to bring up is the issue of retrenchment. What's retrenchment? Retrenchment, in essence, means in a situation where you terminate with a situation where there are redundancy in employee. It's not a situation as though, I'm not making money, I need to cut costs, that's why you need to do redundancy or do retrenchment. That's not the position. The position is a little bit terbalik already. You need to show that the redundancy and not the issue of cost. Okay, so redundancy is known as termination of an employee's service because the employee is redundant. That is, he's regarded as a surplus to the organization. So how is he a surplus? Why is there redundancy? The examples are that certain job scopes are no longer there. There's merger of workloads, and they may be discontinuation of certain production line. Okay, in what situation can an employer retrench its employees? Now, the courts are very fair. They take the position and accept that companies are at liberty to organize themselves and that their objective is to maximize profit. Courts acknowledge that. So if you want to retrench, the most important thing is that you exercise the retrenchment in a bona fide manner. Now, what's bona fide? Two main factors to be considered as decided very early in 1990 are that one, there is a redundancy situation, i.e. You have surplus of workforce, or that certain job scopes are no longer required. And two, when you retrench, when you do the retrenchment, you are in accordance with the accepted standards of procedure. Now, what are the accepted standard procedures, or the SOP? We'll see here. Okay, in essence, you need to show that you've taken steps to avoid retrenchment. Okay, now you will see from this slide that you must freeze recruiting new workforce. You limit the overtime, you limit the work days, you reduce the working days, you reduce working hours. All this. Then you try to retrain the staff. You may even try to tell them there are alternative jobs, whether they want to try. And there's a lot of people talking. Guys, can you mute your speakers? Otherwise, I can hear all of you. Sorry, Amiruddin. I can hear you, Amiruddin. Okay, just mute your speakers, please. Okay, we continue. So it seems that there's a lot of things that we need to do under this guideline. You don't have to do all of it. You don't have to do all of it, but you must be seen to attempt to do at least some of it. Okay. Now this is because these are guidelines. They don't have the legal force. But whenever your retrenchment or your termination is being challenged, at least you say, look, I have practiced what is known as a fair labor practice. Fair labor practice would mean that you will try to avoid retrenchment. Okay. Next thing, whether a retrenched employee is entitled to claim compensation. Okay. In essence, yes. It's provided under Section 3 of the Employment Regulation, Retrenchment and Layoff Benefits 1980. In essence, he has to be terminated or retrenched, and that his contract is more than 12 months. Now, then everybody is thinking about getting payment, right? That's not so. There are quite a few exemptions towards this retrenchment benefits or this termination benefits. In essence, the people whose contract is less than 12 months, and if there is termination apart from retrenchment, okay, for example, if it's retirement, misconduct, or you resign yourself, then you don't get these payments. Okay. Now, there are two other situations which is quite interesting. Actually, one of that was discussed recently in another seminar, where the contract of service is renewed, either in a new management or this was discussed in a different seminar, whereby what if the company is taken over by another new shareholder or new investor or new owner. So if the contract of service is renewed, okay, and the new contract is similar and not less favorable than the one that you have, then you won't get this payment. Okay, but further, if the new employer offers you a renewal and the new contract is again not less favorable, but you have refused to accept it. So in essence, the employee must accept the new contract so long as it is not worse off. Otherwise, you will not be eligible for the payment. Okay, so how much do you actually get? In essence, it's anything between 10 days per year up to 20 days per year. Okay, I'm trying to make sure that I don't go over my time. Okay, what are the employer's obligations under this MCO, or more relevant in this COVID-19 situation? So apart from what the government has said, that you must provide the 10 points SOP that you must have to make sure that you control this COVID-19 infection, there is this act known as OSHA, the Occupational and Safety Health Act 1994. Just remember that if you do not provide, it's the employer's obligation to provide all the employees with a safe place to work. Otherwise, there is a penalty. You can be fined up to 50,000 or a 2-year jail term or both. It's quite serious. The following are a couple of guidelines as to what to do. This first one is produced by the Ministry of Human Resources in February. I think it's quite draconian. Some of the things, especially if you see in paragraph 3, 5, and 6, it suggests that during the quarantine time, even if the employee doesn't work or that he's finished all his sick leave, you must pay him. Yeah. The other one is a guideline produced by the Malaysian Employers Federation, MEF. It's actually quite good. It helps you to see what is the fair practice towards the employees. Now, both of these are guidelines, so they don't have the force of law, as I was saying, but it would help you to minimize your dispute between the employer and employees. Now, we move on to, I prepared 4 common questions that has been put forward to me. The first of which is, must employer pay full salary to employees instructed to be placed under quarantine? Okay, and the answer is that for employee under quarantine, you have to pay full wages. Okay, under quarantine, you need to pay full wages. In other a point to note is that in this situation, it's important to discuss with your employees as to what they can agree to within the ambits of their employment contract. You can negotiate. At this juncture, I have something a little bit conflicting. Although those are the law, I take a slightly different position in that although we are supposed to pay full salary, and the government has given guideline that during this MCO, the employer cannot deduct salary from the employees and they must pay full pay. I take a slightly different opinion. And some I think more senior practitioners are of the opinion that this guideline given by the government has got no legal basis. I take that position because under the employment contract, if we look at Section 2, Section 2 is quite clear where it says that wages is something that the employer pays the employee for work done. So during this MCO period, I see that if there is no work done, how am I supposed to pay you wages? So that's my position. Now, this is of course not tested in the courts, but I think it's a useful argument. Okay. Next. Okay, for employees who are not coming into office due to the MCO, are they still eligible to full wages? In essence, again, there are 2 positions that can be taken. I think the first of which is, again, because of MCO, if they don't come to work, the government says you have to pay. Okay. This is in line with 1982, again quite an old decision, where it's known as Dunlop Malaysia Industry against Dunlop Malaysia Industry Employee Union. In those cases, in those days and even until now, I think the workers' unions are all very strong. And in essence, that decision was that even if the employee has no work, okay, the employee must still pay wages. However, in a slightly even older case from UK, it's called Browning and another in 1928. This is where there was a closure of a mine, and because of the mine not being safe, and so the employees, the miners, were taken off, and the employer and the court found that the mine owners, this is important, should not be liable to pay wages or damages to their workmen during the time which was reasonably to put the mine into safe condition. So one could argue that while it is not safe to come to work, it's not my fault, it's not the employer's fault, and so we should not be made to pay wages nor compensation. Again, these are the scenarios whereby there's no court decision as yet in Malaysia on this particular point, but something that the employers can consider in their negotiations with the employees. Okay, we move on to question 3. Can employer request specific employee to stay away from office or workplace or to work from home? The simple answer is yes, so long as it is not in contrary with the contract terms. The employer has the discretion and the prerogative to tell the employee where to work, especially where you have contracts where there are various branches where you should be working. The employer has the right to direct employees to go to which branch. And in this case, I think it can be expanded to working from home or not come to work. But most importantly, you cannot cut their pay. Okay, question 4. Can employer request its employees to volunteer to take up annual leave in lieu of wages? In short, no. The employer can negotiate, and that's what I said just now. Can negotiate and offer and suggest to the employees that because of the MCO and because of COVID, business is very bad. We would like to request that you consider taking annual leave or take half pay or even no pay. Now, these are all subject to the employee's consent. If the employee refuse to agree to your request, there's nothing you can do. You must pay him full pay. Very important is that you must not discriminate against those people who disagree with your request. Okay, so it is also just to deviate a little bit, there are questions being asked in scenarios like this. Can you say, look, it's majority, or is it 70-30 and 90-10? The answer is no. Only those who agrees with the reduction of pay can these terms be enforced onto them. For those who doesn't agree, even if you have 99 out of 100 agreeing to the terms, but one doesn't agree, that one particular employee you will have to make full pay. Okay, that's in essence what we have for employment. Whatever questions that you have, please hold on, put it down. I think you can send it in, but we'll move on to contract law for now. So let me have a sip of water. Okay, we're ready. Okay, we're pretty good in time and speed. Let's start on issues pertaining to contract. To start, no doubt, I think COVID-19 and MCO has affected many SMEs. Many of the contracts, because of this COVID and MCO, have been maybe breached or cannot be performed, cannot be executed. So there are very serious results, consequences, and repercussions as to this. At this juncture, I like to just bring up the difference and the distinction, and that we need to understand there is a difference between the COVID-19 issue and MCO. Of course, MCO at the moment for present discussions is only limited to 6 weeks. So whatever happens during MCO is an issue. However, I think COVID-19 is a much bigger issue. COVID-19 would include the period just before MCO, and for that matter, would apply to scenarios after MCO. We'll see more details following up. Okay. Let's start with the first one, force majeure. Force majeure is a contractual thing. It is French actually, which means superior force, which in essence means that it is an event that's beyond the control of the parties. Yeah. It is an event beyond the control of the parties which impedes the performance of the contract. This is a typical legal force majeure clause. Okay, it reads, a force majeure clause is normally used to describe a contractual term, okay, by which one or both of the parties is entitled to be excused from the performance of the contract. Okay, I think we first need to understand that in essence, it's contractual. It must be contractual. Whenever there is no such contractual term, you don't need to talk about force majeure. So I will touch on Reda's suggestion on asking the government to enact a provision to make CMO force majeure later. MCO, sorry. Okay, let me continue and say, in essence, to be excused from the performance of the contract in whole or in part, or is entitled to suspend performance or claim extension of time for the performance. So when you have a force majeure, it need not be simple for termination. It could suspend the performance, or it can give you extension of time. Sorry, I'm having some problem with my slides. Okay. Yeah. Okay. So, like I said just now, in essence, a force majeure depends solely on what the parties have intended in the contract, i.e., force majeure must be a contractual term. It cannot be implied into a contract. If your contract does not have a force majeure terms, there's nothing to talk about force majeure. Okay. So, if, like I said, if force majeure is not in the clause, not in your contract, you cannot rely on it. You cannot imply it. I'm having some problem with the slide again. Maybe my computer too old. Okay, we're back. We're back in business. Okay. How do we activate this force majeure clause? These following facts must be proven before you can activate the force majeure clause. Number one, that event must be referred to in the force majeure clause. Number two, it must prevent your performance of the contract. Number three, it is beyond your control and that you cannot avoid it. This is captured in a 2004 decision. Okay, the key points for a force majeure clause. When you look at a force majeure clause, this is what you need to look at. Number one, of course, whether you have force majeure clause. And then you must look at the scope of the force majeure clause. We will have some examples later. Number three, was the force majeure clause just a second, yeah. Okay, let's continue, sorry. Okay, whether there's a force majeure clause, what's the scope of the force majeure clause, then number three, whether the force majeure event that happened is something that has been foreseen. All this you will see a little bit clearer later. Number four, would the force majeure clause event render the performance impossible? I have something on again. It's a set. And number 5, was there any procedure that is stipulated in the force majeure clause for you to utilize this force majeure clause? Now, this key point is very important. All of you must try to understand it. Sorry, guys, I'm having problems with my slides. Okay. Now, what we're facing now is COVID-19 and MCO. A lot of the force majeure clauses actually make reference of what epidemic is. So is COVID-19 an epidemic, or is it what is known as pandemic? I think we Googled this in the dictionary. In essence, they are similar. I think they are applicable even if the world has announced and declared COVID-19 as a pandemic. Whenever you have clauses that mentions epidemic, I think it would apply. Okay, what is the effect when the force majeure clause comes into application? One scenario would be that it becomes a moratorium. The performance of the contract is suspended, and after the force majeure event, you can continue with the contract, and the contract would have extension of time. The second scenario is that if the force majeure event is prolonged and it is very substantial, you can terminate the contract. Okay, we're moving on to some examples of the force majeure clause. The first one that we have is under PAM contract. Let's take a look at it. This is quite specific and well defined in Article 7. It defines force majeure as any circumstances beyond the control of the contractor, and it stipulates very clearly by Terrorism Act, governmental or regulatory actions, epidemic, and so on and so forth. So the events are very specifically stipulated. Now this, I think, is quite a narrow clause because only in these events stipulated that can you claim the benefit of force majeure. A different standard form, AIAC contracts. This is slightly wider, and I think I'll explain to you why now. In Article 9.3, it says force majeure means an exceptional event or circumstances which basically defines beyond parties' control. Party could not reasonably have provided against. Parties could not have reasonably have avoided or overcome, and it is not substantially attributed by the party. Okay, now this standard form is slightly, to my mind, better because it says force majeure may include, okay, in Article 9.34, may include, but is not limited to. So in essence, they will give you examples, but you can argue that so long as it is beyond your control or within the ambit of this clause, then you can try to apply force majeure. So it says may include but not limited to exceptional events or circumstances of the kind listed. Okay, so when you have a listed events, so long as it is similar to that, then you can argue. So because the wording says included but not limited to, unlike the PAM contract. Okay, we have another example. This is used in oil and gas industries. The clause reads like this: neither party shall be in breach of this contract if there is any total or partial failure of performance by it or its duty and obligations under the contract occasioned by any event beyond the control of either party. Okay, so it gives a stipulation as it must be event which is beyond the control of either party. Then they gave examples: act of God, fire, typhoon, act of government or state. So this is one of the clauses that's being used in oil and gas. Okay, so the wording that they use here is occasioned by any event beyond the control of either party. So it's not a dead end because you use the word including. So you may have other things that is beyond your control, and you may argue that it is applicable. Okay, the next example that we have, this is quite good. Something that I like. This is used in a lot of sales and purchase agreement. It's captured in the time for delivery of vacant possession. I think very close to Reda's chart. In essence, this clause reads like this: vacant possession of the said property shall be delivered to the purchaser within 36 months, or in some cases 24 months from the date of the agreement, provided that in the opinion of the vendor's architect or engineer, this is a precondition that is being used in this sort of force measure. So you need to, that's why I say, look into the clause. In this case, in the opinion of the vendor's architect and engineer, completion of the building or delivery of vacant possession of the said property is delayed by reasons of exceptional inclement weather, civil commotion, rights, so on and so forth, okay, or force measure. So force measure means something which is beyond your control. In this clause, it basically sets in two conditions. One, that it is in the opinion of the architect or engineer whereby completion is delayed. Okay, it must cause delay. If you have any these events that does not cause delay, it doesn't come into this clause. And second part of it, whereby it says, I think there we are, 4 lines from the bottom. If the vendor's architect engineer shall make a fair and reasonable extension of time for completion of the building and delivery of vacant possession. Okay, so it is up to the architect or engineer to give the fair and reasonable extension. So this is a clause whereby it tells you in what situation can the force measure be used, and when the force measure is used, who will decide how much of it can be used for extension of time. Okay, next thing, how does force measure work as a defense against LID? So as in the example that we have just now in SPA, in essence, when the force measure clause is being applied, you would have a scenario whereby LID will not be payable. Okay, other impacts on the contract. In this case, the construction contract. In most of the contract for construction, we will look at whether force measure would affect extension of time, EOT. Okay, in PAM contract, in essence, whenever there's a force measure, you will be allowed to have extension of time. This is provided under clause 23.8. That's in the PAM contract. In AIAC contract, the extension time is also granted when there is a force measure. Now, apart from EOT, what is known to the contractors, the employees in this scenario, is not only the extension of time. Because during this MCO period, machines are still there, some employees may still be there, and there are loss and expense. The question is whether loss and expense during this MCO can be claimed. I think not, in essence, because in order to claim for loss expense is in essence an issue of fault. Okay, only if the employer is at fault will you be able to and justify to claim for loss and expense. Now in PAM contract, clause 24, actually provides for how you can claim for costs, but it's silent on force majeure. For AIAC, is even more clear. In essence, clause 24.1, the contractor is not entitled to claim for any loss or expense arising from force majeure. Okay, that in essence talks about force majeure. Let me just recap. In essence, force majeure is a scenario that it must be provided for in the contract. Okay, we mentioned that because of that, you need to, whenever you have an event of force majeure, you need to look into the clause and see whether the event is covered by the force majeure, whether how the force measure should be applied, and what is the effect of that force measure. And here I'd like to just quickly pause and like to speak and give support to Reda's suggestion to the government to suggest to have an enactment for force measure to make MCO a force measure event. But what is important is also to look at two things, because even if you declare that the MCO is a force majeure event, if the contract doesn't provide for force majeure, you would have an issue. Okay, how does that act provide for it? So the act must not only stipulate that MCO is a force majeure event, it must provide how to apply force majeure in various contracts and how that would help to alleviate the problems that the contractors may have. Okay, now we move on to frustration. Now, frustration, the doctrine of frustration is something that would help you when there is no force majeure clause in your contract. Now, in order to use force majeure, it is provided for in the Contracts Act. The Contracts Act 1950 provides whereby the wording is contract to do afterwards becoming impossible or unlawful. A contract to do an act which after the contract is made becomes impossible or by reasons of some event which the promisor could not prevent, unlawful becomes void. So what it actually means in layman terms is that when you enter into a contract, okay, for reasons that is beyond your control, okay, which is not cannot be prevented, the contract becomes impossible or unlawful to perform. The contract will and can be argued to become void. Sorry. Okay. This one we need to understand a little bit more detail. So a contract is frustrated when a change of circumstances render the contract legally or physically impossible to perform. Like I said, when you enter a contract, after it's been entered, it suddenly cannot be performed because either by law or by physical. Okay, in the case in 2007, it's stipulated there in that case where it says three elements must be present in order to argue for frustration of the contract. Number one is that there is no provision in a contract to provide for that event, because if it's provided, it should be in a force majeure clause. Number two, it is not self-induced frustration, something that you're not responsible for. The act is not, the intervening act is not caused by you. And number three, it radically changes what the performance is required of the contract. One interesting point is that some employers may argue, some contractors may argue, because of MCO, certain items become very expensive, and therefore I cannot perform the contract. And I want to argue for frustration. That has been decided in 2008. Even if the contract becomes more difficult to perform or is more expensive, that is not reason for you to claim frustration. Now, how and would COVID-19 or MCO give rise to frustration? Now, you need to look at the contract. I mean, the long and the short of it is you need to look into the terms of the contract, whether the contract provides for it. Number one, if it provides for it, it should become force majeure. If it doesn't provide for it, then is it an issue that it's not caused by you? You can't prevent it, and it changes the whole perspective of the contract. We really need to see the contract and what are the duties of the parties. Okay, I'll give you, these are some examples. I think I'm running a bit late. I better move on. So you read it for yourself. In essence, the contract will be rendered void when frustration applies. But there are exceptions where, for example, there are parts of the contract, okay, that you have paid for but not performed. You can ask for the money to be repaid, okay? And the part that hasn't been paid need not be paid. However, if there's any benefit, okay, that you have received prior to the frustration, those benefits can be recovered, can be claimed for, but does not go beyond the expenses that has been spent on it. Okay, quick conclusion. In essence, whenever you have a contract and you have issue, you look into whether what is the situation of the contract. You look at the contract in detail. Okay, you need to see what are the extent of the terms of the contract. Okay, and wherever you need to, you try to give early notice to the appropriate parties. For example, if it's a force majeure, something happened, you should be prepared and write to the other party and say, hey, I look at this is force majeure, it's provided for the agreement, in the clauses of the agreement. So for this period, this is what I propose to do. According to the contract, these are my rights. Okay, so you should inform the other side, give notice to the other side so that you're prepared, so to avoid any dispute. Okay, if it is not provided by the contract, then very quickly, give notice to the other side. Hey, this is something that we have not prepared for. It's beyond my control. I cannot prevent it. What do you like to do? How can we resolve it? In essence, that is my advice for contract. Okay, I think that's in essence my part of the contract, my part of the presentation, ladies and gentlemen. For the next part of the presentation, it will be conducted by my partner, Ms. Nurul Fahina. She has been with me since more than 9 years ago. She chambered and have been with me since the chambering days. She practices in essence mainly in insolvency. So I'd like to invite her with Sis Chin's permission to start the other part of the presentation.
Sure. Thanks, Arthur. I think you need another sip of water.
Thank you.
I think very precise and very accurate, even with some good example that for us to take a look. And then for all of you, if you have any question, you can start typing in. We will gather the question and start answer after the session over. after the presentation over. Thank you, Arthur. We move the slide to Ina. Ina, you can go ahead. Ina there?
Hello?
Yeah, we can hear you. Good.
Sorry. Thank you, Mr. Chin. Thank you, Mr. Arthur. Sorry that I think I forgot to unmute my speaker. All right. I'll be sharing with you information or basic legal viewpoints on insolvency. Let me try to share the PowerPoint slides that I have prepared for all of you. All right. Can you see my screen? Okay. Can you all see my screen? All right. Okay. Thank you. Thank you for the response. I see that. Eric.
I think we can't hear you. I don't know the rest. You hear? Oh, you hear?
We can't hear.
Ina, we can't hear you, Ina.
Now we can hear you.
Okay. Should I repeat what I have shared?
Please go again.
Sorry. All right. So let me just repeat the important points. Bankruptcy proceedings is a proceeding made against individual governed by Insolvency Act, which came into force 6 October 2017. Okay, it was previously governed by the Bankruptcy Act. What is the minimum threshold to make a person bankrupt? Answer is 50,000 ringgit. The previous threshold that was regulated under the Bankruptcy Act was 30,000, but it is now increased to 50,000. What is the prerequisite? Sorry?
Yeah, someone has clicked on the mic. Can you off your mic, please?
Okay.
Ina, is it you using two devices?
Before, is it now clearer? But I think I better off my handphone first.
You cannot on two devices.
Okay, how's the sound now? Has made I've turned off my handphone. It sounds better, I think.
Mic. Oh, vậy thôi.
Okay, is everything all right?
Ina, have you off your handphone or
I already turned off my handphone.
so now you only on the WebEx in your laptop, right?
Yes.
So you already log out from my handphone, right?
No. I'm only on phone. I'm only on laptop. Sorry.
Your handphone already signed off, right?
Correct.
Okay. Now should be all right.
Okay.
You may continue.
Continue. Huh?
Yes. Thank you.
You need to what does the creditor need to commence filing to commence the bankruptcy proceedings? The creditor must get the court judgment of a minimum sum 50,000 ringgit. Okay. Once
Still
it
very noisy, yeah. Still very noisy, yeah. I don't know. Do you have any other devices is on next to it?
no. I don't. I'm only with my laptop.
Okay, now it looks better. You stay at this.
Okay. Can a creditor file bankruptcy proceedings without having a judgment? The answer is no. Okay, but I want to share with you. The first thing if you receive a bankruptcy notice, that means if you were not served with any summon before receiving the bankruptcy notice, you only realize that there is a bankruptcy proceedings filed against you. What do you need to do? You have to check in the bankruptcy notice. Why is it still very noisy there?
Yeah, I think Ina, it's probably your Wi-Fi. Yes, maybe also because of the time constraint. Ina, with your permission, can I take over the presentation and just give a very quick one?
Sure. No problem.
Sesh, I think
Better that
we are
way.
running short of time, and there's quite a lot of questions that's coming in.
Do
Okay, I think
stop hearing?
let me just very quickly go through. Jekyll, can you let me share share the contents? Ina, sorry, let me try to do this over here.
No problem. Stop sharing my slides, huh?
Okay. I'll come through my side.
Okay, Arthur, you may go on.
Thank you. I'm trying to extract the slides. Just give me 1 minute, yeah. Let me get the slides up. Okay, I think we are on. Hi, yes, Checker, is the slide on? Is everybody looking? Can see the slide?
Yes. Yes.
Okay, good.
Right, yes, go ahead.
Okay. Very quickly, I think we only have until 4:30. I think I overrun my time a little bit. In essence, guys, for insolvency, what we wanted to tell you is that the various types of insolvency, one for the individual, one for the company, and in individual, the bankruptcy minimum threshold is 50,000. Okay, it requires a court judgment before the bankruptcy can happen. So if somebody wants to sue you for bankruptcy, they must get a judgment first. Without a judgment, they cannot sue you. A lot of slides I'm going to jump so that we can save some time. Now, when you receive a bankruptcy notice, it means that legal action has been started against you, and you need to file an affidavit to oppose it. If you don't, bankruptcy will be made against you. There are with bankruptcy scenario, there is a new arrangement whereby before you become bankrupt, you can apply and get somebody to do a voluntary arrangement for you so that your bankruptcy actions can be withheld for the moment. Okay. I'm going to move on. What the bankrupts can do, I won't speak for the moment. Now, even if you are bankrupt, there are two ways to get out of it. One is annulment, the other is discharge. The good thing about annulment is that when annulment is ordered against you, it will have no records whatsoever. In essence, it means that the bankruptcy ought not to have been ordered against you. So, but with discharge, you will have a record that you were a bankrupt and that you have been discharged. Okay, there are various other ways under the Insolvency Act whereby a bankrupt can be discharged. Okay, it is provided in the slides. I won't go through it. I've explained what annulment and the difference between annulment and discharge. Okay. Maybe I'm moving too fast on the slide. Okay. Okay. Computer is not catching up with my speed. Okay, the next issue is insolvency. Okay. Insolvency for company is known as winding up. For winding up, originally the threshold for winding up is 10,000, but because of this MCO, the government has made some amendments to it. The threshold for suing a company, this is new, guys, has been changed from 10,000 to 50,000. The previous statutory notice, which was supposed to be 21 days, now has been lengthened to 6 months. All of this is the government's move towards helping you to get over this period of COVID-19 and MCO slowdown. Now, one thing that's important is that for winding up procedures to be commenced, no judgment of the court is required. So be careful. You may say, look, nobody sue me suddenly. You know, there's a notice that is on my company SEC's door. Why is that? It's because under 465, the notice can be issued so long as the issuer feels that the debt is indisputable. So it's very important that once you get a notice for winding up, you run to your nearest friendly lawyer to get advice. If your debt is seriously disputable, you can go to the court to get an injunction to stop them from proceeding. It's very important that the winding up petition doesn't get proceeded with, because if it's proceeded, a lot of your bankers may call on you, okay, and call on your loans, and you will be in trouble. Okay, there are a couple of corporate rescue mechanisms that is provided. One of it is known as the corporate voluntary arrangement. This is an arrangement where the company is still in charge. The company will come out with proposals and talk to the creditors as to how to pay everybody. In essence, this is available if the company is still solvent. Okay. Okay. The other one is called judicial management. This is where you are in trouble, in essence. So you apply to the court and says, look, I'm in trouble. Can you arrange the creditors to sit down and we have a meeting to this? This is very similar to the 176 that we had before. However, the difference is that under this scheme of arrangement, there is no moratorium against all the litigations. So the litigation can still carry on, but you can apply via court for a restraining order, stopping everybody from suing you. Okay. So in short, this is what insolvency is about. What I wanted to show you is that in this period, it's very important that you know what are your contractual rights in terms of employment, in terms of your contract, in terms of force majeure, frustration, and in the worst case scenario, you must be prepared, okay, to know what are your issues in terms of insolvency. If you see something, you know when you need to go and see a lawyer, be aware of it, and don't just do a layman thing and say, look, I try to resolve it, I talk to all the creditors. It's not as simple as that. That I think is the conclusion of our presentation. Okay, CS, thank you very much. Maybe we can take some questions.
Thank you, Arthur. I think it's you have a good line. Your voice is clear. And, we can hear you very nicely. And I think there are a lot of questions that we in our mind, but for all the participants here today, you can key in your question, or we open up for you to speak up if it's possible. If you have time, we will do that. And I have one question to Arthur for employment. For instance, if I want to terminate my staff, right? Should I do the same time for all, or I do one by one? Can I do that, or I must do termination at once? To the fact that if, let's say, I have 10 people, I want to fire 5, I have to do the same time, or I can just do one by one.
Okay, are you talking about termination, or are you talking about retrenchment? If you terminate an employee, it is a one-to-one scenario. It's basically that particular employee that you wish to terminate. Either it's at the end of the employment, or that they have not been performing, they have been negligent, they misbehave, then it's a one-to-one scenario. But if you're looking at, there is redundancy, or in other words, in layman terms, I really need to cut costs, there are things that we are not doing anymore, and these are the stuff that we don't want, then it has to be overall. It has to be applicable to all those redundancy employees at one go. All of them must be offered reduced working days, working hours. You don't employ any more new employees for that section. I hope that answers your question.
Yeah, okay. Thanks for that. So in other words, means, for instance, can I have stages? If I have many staff, maybe I have 200 or 300 staff. For the first stage, I do for 20 people. Maybe next month later, I do another one. Can I do that?
No. What you do is you do it by section. For example, if you have 4 or 5 sections in your company, first of all, you're saying overseas sale. Okay, overseas sale is redundant. So you do overseas sale first. The whole section, the whole department on that. Then you look at marketing. If your marketing division, you only need 2 people, but you have 10. So you apply for all the 10 as to how the redundancy will work on a departmental basis.
Okay, thank you, Arthur. I think it's clear. Jacob, can you check whether we have any other question here or in the Facebook that you can...
I can see one from Putri. It says, hi, Arthur. I would like to ask for the employees under probation. Let's say the probation should end on 15th of April, but MCO is extended. Does the probation period need to be extended as well? Good question. Putri, no. I think at the moment everything is suspended. Okay, so what happens is that if your probation finish, let's say April 15 today, and there is nothing you can do, I think your probation will not be extended. Okay, it means it finished on April 15th, but assuming that the MCO is over on the 28th, so 29th, the company must give you an answer as to whether you are accepted or your probation is extended. Okay, or they don't want you. They have to give you notice by then.
I see another question from Casey Wong. Contract have force majeure clause, but it doesn't mention MCO or lockdown. Does this mean that we can activate this clause?
Okay. For that, I didn't see that question, but let me try to answer that. If you have a force majeure clause, but it doesn't cover the event, then you need to read the force majeure clause very carefully, whether it is a narrow force majeure or is it a liberal force majeure. When I say narrow, it means that force majeure clause, it would stipulate as to in my slide, the first example that we have, it stipulates the events and no more. In those scenarios, if your force majeure says that it's a narrow force majeure, then you will not be able to use it. Okay. Now, if it is a force majeure clause where it gives example, for example, it says including or not limited to, things like that, then you may look at whether it is within the category of the events. Then you can try to use your force majeure.
Okay. So next question, we have a question from our Facebook and also from our participant here. Okay. First question. PM say employer can negotiate with employee for company suffering during this MCO. What's the limit to this negotiation? And also, what are off limit on the negotiation?
Okay. I think the question is what we can discuss. Anything you can discuss. Although in the Employees Federation guideline, they would say that you should not reduce anything more than half the time of employment or half the pay. It's really up to you and the employee. Whether the employee is agreeable to say, look, okay, during the MCO, I take no pay at all. But if the company makes money at the end of the year, you give me extra bonus or something. There is, in essence, in law, no real limit as such as to what you can discuss and negotiate with your employee.
Okay, thank you.
Thank you.
Okay, next question. Can EOT be granted under the standard SPA?
EOT granted in a standard SPA, do you say? SPA is very clear. I think most of the Schedule G and Schedule A statutory agreements, the wordings are very clear. It cannot be varied. Okay, so in the SPA agreement, you look into your force majeure clause, and what is the effect of the force majeure clause? The force majeure clause that I have used as an example in SPA, it basically extends the agreement so that you cannot claim LED, but it's subject to what the architect decides is a reasonable extension of time.
Okay, thank you. Okay, next question. In the event of force majeure can be applied, can frustration clause be implemented whereby penalty charges waive or delay of works as EOT?
Sorry, come again.
Okay. In the event of force majeure cannot be applied, can frustration clause be implemented whereby penalty charges waive or delay of works as DOT?
Okay, I provided a slide as to what is the effect when frustration applies. In essence, when the force majeure clause cannot be applied, okay, so it's beyond the contract. So what is necessary for you to establish is that it's something that the parties did not contemplated in the contract. Okay, so it's not contemplated, but the event makes the performance of the agreement void. Therefore, you do not need to perform the agreement anymore. So there lies the issue. Whether after that you can then go to court and say, look, there are parts of the agreement that I can still perform. So long as I can perform it, then parties should be able to perform it.
Okay.
It's a bit technical. Maybe I should make it even simpler. Let's say you have an agreement before the frustration, you have performed 20%. So that part of the 20% you can be paid. Then because of the MCO or the COVID-19 period, 40% of the contract cannot be performed. So those contracts will be void. But the remaining 40, 30, live with 30, right? The remaining 30%, if you can perform it, you can try to perform it and get paid for it.
Okay, noted. Okay, next question. If a company has registered a staff for the RM1002 salary package, and if the staff still willing taken a few days of unpaid leave, will the CEO still able to receive the incentive? Will the company still able to receive the incentive?
I think I think in the declaration form for the incentive, I think CS will be able to assist you better there. But according to what I know, in the statutory declaration, you have to stipulate that you will not deduct pay and that you will not terminate. So it's nothing to do with unpaid leave taken by the staff. So in essence, my answer is yes, the company is still eligible for the subsidy.
All right.
Okay, noted. CS, you want to add on?
What Arthur says is true. As long as you do not terminate the staff, then you are eligible to claim. Right? And those like leave or those are just part of the normal thing that you do every day. So it's okay. You still can go ahead and claim.
Okay, noted. Okay. Next question. May I confirm for reduction of salary must be submit form PK 30 days in advance?
Sorry, I'm trying to get the question. I confirm for the reduction of pay.
Salary, yeah. Must be submit
Reduction
form.
of salary must submit form with PK 30 days in advance.
Yes.
I don't know the answer, to be honest. If you give me your details, I will get the confirmation and revert to you. I think this is question by May Chua, is it?
Yes. Okay. Okay, then we move on to next question. How?
Just get me the details. I'll get the confirmation to you.
Okay. After you can, after this session, you can, after you get the detail, you can reply it on our SME Malaysia Facebook page.
Sure. Sure.
Okay, then we move to the
I
next
think
question.
we don't have too much time, but just to say very quickly, whoever has got any questions, please do post it over to SME, and I'll do my part to reply and revert to you.
Okay, thank you. Okay, next question. How about a contractual worker due during the MCO? This is from the Facebook question.
When you say contractual, you mean day contract, or you're talking about even yearly can be contractual employees. If they are daily contract, then it means that if they finish the day, there is no more contract.
Okay, the question didn't state any contract type of the worker.
Yeah. So in essence, for contractual employees, their employment completes, okay, at the expiry of the contract. So unless you give him a new contract, there is no contract. And he will not be eligible for compensation unless his contract is more than 12 months.
Okay. Now we have a question from the floor that, okay, if a company granted special rest day as replacement of overtime compensation, are these classified as provided leave to staff and treated as annual leave?
If a company grants special rest day as replacement of overtime compensation, are these classified as provided leave to staff and treated as annual leave? Okay, the answer is this. Depends on your contract. Okay, is this so-called special rest day provided in your contract of employment? If it is not, then no, it's a free day. So be careful. If you want to replace the overtime, it should be provided in your contract and that the employee has agreed to it. If it is not, then quickly have a discussion with your employee and that they are happy to accept this change of terms. Otherwise, it becomes a free day and you have to pay their wages.
Noted. Okay. Next question from Jeffrey Au. Allowance like petrol allowance is not in contract. Can company not pay during MCO?
Okay. I hear that. The answer I think is no. Okay, you have to pay. If the allowance is because you cannot deduct any of your allowance and your pay, as I understand it. However, in the Employment Act, you are not required to pay any wages where work is not done. So during this period of MCO, you may say, look, your car is not traveling, you're not asked to do any work, to do marketing or come to work and should not be driving the car. You're definitely not driving the car in carrying out your official duties. So in that sense, you can say, look, we're not paying your petrol allowance. But because of the government's directive, it remains a little bit unclear. Okay. Now try to find a clearer answer for you. If you leave me your name, is it from Putri again? If you leave me this, sorry, this is from Jeffrey Yao. Yeah, you leave the details with SME, and I'll try to get you a clearer answer.
Okay, thank you, Arthur.
Add on something on this.
Okay,
So the claim of, if you're going to claim the wages subsidy, gaji including allowance. So if you don't pay the allowance, take out the allowance, then maybe fall below the 4,000 mark of claiming. Then you go and claim. Then we have an issue. So that you have to take note. So once your classified allowance, you have to take in that's the salary.
Noted. Okay, we move on to the last question of today. Okay, also from Putri No. Okay. Based on the just now question, if a company terminate an employee under probation, will the company still eligible for the incentive?
Good question. Under the declaration form, the employee which you are claiming for the subsidy, you must say that you do not terminate them for 6 months, and you cannot. I think there is some dispute as to this part, but I think you can't even cut their pay. Okay, because the declaration form and the directive given by the ministry, there's some gray area. But my question is this: now, if it is during probation and you do not wish to confirm them, then the person is no longer your employee, and obviously, therefore, you cannot apply for subsidy. It doesn't make sense to me. So, your question, if I remember correctly, says that if your probation finish on the 15th of April, so what happens? So by let's say 29th of April, if you decide that you're not confirming the employee, obviously you will not be applying for the subsidy. Yeah.
Okay, thank you. Okay, so any question from the floor?
Give another 5 minutes. If there's question on the floor, then we continue. If not, then we will end the session. Any question? Anybody want to speed up?
Okay, there is a question from the Facebook. Okay, so if the salary is not paid in full because of the unpaid leave taken by the staff, will the company still receive the incentive?
If the salary is not paid in full because the unpaid leave taken by the staff, will the company still receive incentive? The answer is yes. The answer is yes. Because it is not the employer who is terminating nor cutting the pay. It is unpaid leave.
Understand. Thank you, Arthur. Okay. So any question from the floor? If no, then we may end the session for today.
I think we'd like to thank Arthur as well as Mike Chris for having this session with us. From SME Malaysia, we really thank him a lot for getting this session and good information being provided to all of us. I do hope if you still need to have some more answer to your question that we did not put up here, you can email to us, and please register our website to get your copy of the presentation file. We will forward to you. Even in future, why the reason that we want you to sign up as a member, because we want to have more voices from the industry, from the SMEs, whereby in future we want to create any so-called survey or getting responses from all of you, and we will reach out to you through email and through information you provided to us in our website. Once again, I would like to thank Arthur Wang, and also Jekyll and Chang of MyChris for making this event a success. Of course, thank you for all being joining us today. See you then.
Thank you, yes. See you.
Thank you, Mr. Chin. Thank you, Arthur Wang.
Bye.
Thank you.